In this installment of Washington Legal Foundation's Legally Brief, Thomas Dupree, a partner in the Washington, D.C. office of the law firm Gibson, Dunn & Crutcher, will address the unexpectedly broad impact of a recent U.S. Supreme Court ruling, Ashcroft v. Iqbal.
The Supreme Court's recent decision in Ashcroft v. Iqbal is a landmark ruling that defendants can and should use in seeking to dismiss complaints that rest on conclusory allegations and theories that simply do not accord with common sense. Writing for a 5-4 majority, Justice Kennedy held that the court's prior ruling in Bell Atlantic v. Twombly was not limited to the antitrust context, but rather swept broadly across the full spectrum of civil litigation. When Mr. Iqbal filed his lawsuit, few could have predicted that it would turn into a landmark case on pleading standards. Mr. Iqbal, a Muslim of Pakistani descent, was detained shortly after 9/11 and criminally charged. He was detained in the Brooklyn detention facility in a special administrative housing unit. Mr. Iqbal alleged that while in detention, he was mistreated on grounds of race, religion, and national origin. Shortly after his return to Pakistan, Mr. Iqbal filed a lawsuit against dozens of federal officials, including former Attorney General John Ashcroft and FBI Director Bob Mueller. Iqbal alleged that Ashcroft and Mueller had designed and implemented a discriminatory detention scheme that violated his constitutional rights. Ashcroft and Mueller sought to dismiss Mr. Iqbal's lawsuit, but were rejected by the District Court and the Court of Appeals. The Supreme Court, however, took the case and reversed. It held that Iqbal's lawsuit should have been dismissed. The Court's opinion began by reciting the standards that it had set forth in Twombly. The Court articulated what it characterized as the two principles underlying its decision in Twombly. The first is that the tenet that all allegations in a complaint must be accepted as true does not extend to legal conclusions. The second principle in Twombly, the Court emphasized, is the notion that a complaint must be dismissed if it does not set forth a plausible theory of relief. The Court emphasized that in making the plausibility determination, district judges must bring to bear their common sense and their experience. Applying those standards to Mr. Iqbal's lawsuit, the Court held that he failed to state a claim. It held that although Mr. Iqbal made allegations, the allegations were conclusory in nature, and Iqbal had done nothing more than articulate a standard recitation of the facts of a discrimination complaint. The Court's decision is very significant because it eliminates any doubt that the heightened pleading standards set forth in Twombly apply to all civil litigation. In the wake of the decision, scholars and commentators have discussed Iqbal's broad impact in a variety of practice areas, from employment law to securities law to product liability law. Many of the commentators have criticized Iqbal on the ground that it undercuts the concept of notice pleading. But I think that criticism is not well founded. I think the Supreme Court quite properly recognized the important gatekeeping role that district courts play in ensuring that a complaint that rests on nothing more than conclusory allegations is dismissed at the start of the lawsuit, rather than after the plaintiff has been permitted to conduct months, if not years, of burdensome and intrusive discovery. The Court also emphasized that the problems arising from a complaint that rests on conclusory allegations cannot be mitigated through an artfully drafted case management order. In short, defendants can and should make aggressive use of Iqbal in seeking to dismiss conclusory complaints and those that rest on theories that simply do not accord with common sense.
Mr. Dupree has drafted a publication for Washington Legal Foundation on the Ashcroft v. Iqbal case, which will be available on June 19th.